When does a threat against a contracting party make the party's agreement invalid? The court considered that question in EverBank versus Marini. Caroline and Gary Marini, a married couple with 2 children, bought a home in 2005. In 2009, Gary wanted to borrow against their home to pay off considerable debt, but Caroline objected to more borrowing and so informed potential lenders. This upset Gary and stressed their marriage. In April, Gary applied for a loan through LendingTree Loans. When Caroline found out, she informed LendingTree that she opposed the loan. LendingTree nevertheless continued to process the loan. When LendingTree's notary called to confirm an appointment to sign the loan documents, Caroline told the notary she wouldn't sign. Gary became angry, brought Caroline and their children into the kitchen, berated Caroline, and threatened divorce. He then grabbed a large pair of scissors and waved them back and forth while yelling. Caroline, afraid for her children's safety, told Gary she'd sign the mortgage documents if Gary would leave the children alone. The next day, LendingTree's notary came to their home. The notary asked whether Caroline's signature was free and voluntary, and Caroline answered, quote, "It is what it is," unquote, then signed the documents. LendingTree loaned them the money and eventually assigned the debt to EverBank. In 2011, the Marinis defaulted, and EverBank filed for foreclosure. Caroline, now divorced from Gary, answered that she'd signed the mortgage documents under duress because Gary'd threatened her and their children, thus making the mortgage void. Gary admitted Caroline's assertions. The trial court found that Caroline was subject to duress, that the mortgage was therefore void, and granted her summary judgment. EverBank appealed to the Vermont Supreme Court.